Hi, we'd like to welcome everyone to today's webinar, Estate Planning in Today's Environment for Individuals and Businesses. Just a little bit of housekeeping. If this is your first time using GoToWebinar, you can dial in either with the microphone and speakers or with your telephone, whichever you prefer. We're also going to be taking questions throughout. So there's a questions section right on that panel, and you can go ahead and type in your questions. We're going to answer as many as we can at the end. Just in case we don't get to your question, we're going to have the team respond afterwards. So go ahead, put in whatever questions you have, and we'll try to get to as many of them as we can. Today on the panel, we have Ted Beyer. So we have Ted as a licensed certified public accountant in New Jersey with over 30 years of experience in public accounting and tax. We also have Henry Rinder, who's going to be moderating today's panel. Henry is also a licensed certified public accountant in New Jersey and New York with more than 30 years of public accounting experience. We also have two guest speakers with us today. We have Heidi Hansen, who is an attorney at Chiesa, Shanahan, and Giantomasi, and she's also a member with the firm's Trust and Estates and Tax Group. And we also have with us today Stephen Loeb, who is an attorney at Chiesa, Shanahan, and Giantomasi, and is a member with the firm's Corporate and Securities Tax and Trust and Estates Group. And with that, I will pass things along to Henry to get started.
Thank you very much, Amanda, and good day to you all. Thank you for attending our webinar, and thank you to the panelists. And we have really good, experienced, skilled attorneys who specialize in the area of estate and gift and income tax. And we have my partner, Ted Beyer, who's basically providing top-notch concierge services to high-net-worth clients. And our agenda today, when we talked about in the title, Today's Environment, we obviously are describing our experience with shelter at home, COVID-19 issues, and what that means to the world of estate and gift planning. And so we're going to talk about what documents you should be putting in place. What are the probate court issues under the COVID-19? When should you consider a trust as a vehicle for your estate probate or estate planning purposes? Topic that's close to my heart, and that's impact of the current COVID-19 circumstances on valuations of assets, and how that impact actually might help you maximize your estate and minimize your estate taxes. And finally, how individuals and businesses can make sure that the estate is properly protected and prepared for the ultimate. So having said that, I will turn over to my partner, Ted, who will start off by talking about what documents should be put in place for your estate and gift planning. Ted?
Thank you, Henry. Hello, everyone. Let's talk about 4 basic documents. The first 3 are really required in all situations. The 4th one, usually highly recommended in the high net worth space, but it may not be appropriate for everyone. We'll just take them in the order that they're listed. The living will, also called a healthcare proxy. If you ever have a procedure done in a hospital or a surgery center, one of the questions they ask you is, do you have a living will or a healthcare proxy? This is where you appoint someone to make healthcare decisions on your behalf if you are unable to make them. You're in surgery, you're under anesthesia, doctor needs to make a decision. Who's going to help the doctor make that decision on your behalf? That's what the healthcare proxy does. Very, very important document. Also talks about what type of care you would want. God forbid you're in a vegetative state or something like that, or on life support. Very important document. The power of attorney see it referred to as a durable power, a springing power. This allows someone to make financial decisions on your behalf if you're unable to make them. If you have dementia or Alzheimer's, you can no longer manage your own affairs. Who did you appoint as the person to manage your affairs on your behalf? That's what the power of attorney does. and again, a very, very important document. Everyone should have it. Everyone's familiar with the last will and testament. It's a document that expresses your wishes upon your passing, who gets what, and what happens to your assets. The unfortunate part of that is it has to go through probate. It's subject to interpretation, and it can be challenged. That's where the Revocable Living Trust, sometimes referred to as Inter Vivos Trust, comes in. Assets that are in the Revocable Living Trust pass by beneficiary designation, not by the will. It gives you privacy because it's not probated, so it's not subject to the courts. Can't be challenged, and it's a great document, especially if you live in a state that has difficult probate. Florida comes to mind. A lot of people from the Northeast move to Florida. One of the first documents we have them do is a Revocable Living Trust, so they can move their financial assets into that, and that way you avoid Florida probate. So those are the 4 basic documents, Henry. Thank you.
Thank you, Ted. And California is another state, actually, that I've seen the use of revocable living trusts. And for various reasons, eliminating or minimizing the probate exposure, but also privacy of transferred assets comes to mind as well. Steve, as we turn into the COVID-19 circumstances today, can you tell us about what's going on in terms of probate and court procedures as we still, people pass and we have issues and they have to be addressed by court. So what's happening now?
No, it's a great question, Henry, and good afternoon, everyone. To Henry and Ted's point before, what we're seeing specifically, in New York, New Jersey specifically, along with, multiple other jurisdictions, is the courts are delayed. So when someone passes away, as Ted spoke about prior, with a last will and testament, a will has to be probated or authenticated. And given the limited staff, given the limited resources currently in the courts, depending on where you are, there's one last will and testament. That last will and testament needs to be authenticated by the court. So what we're seeing is, for example, in certain courts in New York, they're not even open for business. So when you have a will and you have one original will and that will needs to be sent to the courthouse, we're discussing with our clients, even if we FedEx it, we're discussing with our clients the risks of doing that and whether they're better off waiting a little bit until the courts are better staffed in certain jurisdictions. So having a revocable trust, which becomes irrevocable at passing, is very important in these times because it avoids the necessity to probate a will. So if there's a trust and that revocable trust is funded, you could avoid probate. So we have a case going on now in our firm where we have clients in the UK who are named executors of a will, and there's a shutdown in the UK. So getting them to have the ability to have documents notarized is very, very, very challenging. So it's sort of the system that we're dealing with, given that every day we're changing, is the courts are delayed, the courts are closed, and it's very difficult to get an executor appointed. And remember, the executor of an estate is the individual or the institution that has the right to really marshal the assets out of that estate. So until that executor is appointed, there's limited things that can be done on that estate, which includes selling the home, transferring assets. In many states, when someone passes away, their estate is frozen. In some jurisdictions like Florida, there's a limited period of time. In Florida, it's 3 months where the estate is typically frozen. And until the executor is appointed, really nothing can happen. Once the executor, in Florida it's called the personal representative, when they're appointed, there's a 3-month period of time where really distributions can't occur without court action, because there's a time period to allow creditors to come in and present claims during that period of time. So when you're dealing with all of these things, it creates a delay right now, which for a lot of our clients, we've been able to avoid with revocable trust, as Ted mentioned. But, with the last will and testament, we're dealing with those things. Then you have the situation where you have multiple ancillary proceedings where, let's presume someone owns real estate in New Jersey and Florida. If they don't own it inside of a trust, there's what's called an ancillary probate proceeding. There needs to be a probate done in New Jersey and in Florida, in my example. And now you have multiple delays within the courts because of really its lack of individuals that are being able to source it, and it's just a difficult time frame to get original signatures and original documents. Some jurisdictions are better than others in dealing with this, but not all. So there's a lot going on, and sort of the planning structures are changing given this to try and avoid going forward our clients collectively in this position.
Thank you, Steve. As we move to the next slide, I'll turn over to Heidi because she has been my go-to trust lawyer. We do a lot of litigation in my department, and trusts do come up as something that's needed, and generally Heidi is the go-to person for me. So Heidi, when a trust is needed.
Thank you, Henry. As both Steve and Ted have already discussed, with the revocable trust, if you have privacy concerns, those are a great option because the will is a public document. Anybody can read what is in a will. So if you want to keep private what you're doing with your estate, a revocable trust is a great option. And as Steve just discussed, if you have property in multiple jurisdictions in each state, you would have to do an ancillary probate. So if you own homes in several states, it's great to hold them within this revocable trust because they're owned by the trust. At your death, nothing has to happen within those states. It's just continued to be managed by your trust. Another great feature of a revocable trust is as the person ages and is perhaps no longer able to manage their own assets, the backup trustee can just step in and continue to manage everything as it's currently held. They don't have to make any changes. They don't have to, file anything extra. It's all within that trust, and so they can just step in and manage it on behalf of the individual, and those assets are still available to them, and they can use them for their benefit. It's just a different trustee than it's typically the person who created the trust for as long as they're able. The other thing that was mentioned before is, if you think there's going to be a will contest, a revocable trust is a great option. And in New Jersey, there's a procedure that you can follow where you give notice to your beneficiaries, and it basically they're going to have to challenge it now while you're still alive. And who's better to say what your intent was with your plan than yourself? So if you think you're going to have somebody who's going to create trouble after you've passed and you want to, be kind to your fiduciaries, this may be a very good option. Deal with the conflict now so that your fiduciaries don't have to deal with it later. And then the other thing is that it provides for flexibility if the grantor of the trust should become incapacitated. There's ability to do gifting. And as I mentioned before, it's kind of seamless because the trustee, your successor trustee, steps in and can kind of pick up where you left off so that, you can do some smart tax planning.
Thank you, Heidi. So the question is, as we move on to the next slide, why are we discussing this topic now? We are sheltered at home, COVID-19, and frankly, from the matrimonial side of law, what we are seeing is arguments that businesses are not worth as much as they were before COVID-19, that there is such a huge uncertainty and such a huge risk. And in some cases, the actual lack of liquidity and lack of revenues that could potentially drive some of these businesses into a bankruptcy. So there is real tangible factors that point to much lower values for businesses. So once you consider that point, you can probably see how that translates to this may be an appropriate time to do some gift and estate planning. Steve, would you like to pick from my point and elaborate on this further?
Yeah, no, Henry, you said it well. I mean, I think there's never been a time more where cash is king and liquidity is so important. And if there are depressed valuations right now, just to give some history, and under the Trump tax laws currently, the exemption for estate and gift tax is $11.58 million per person. So each individual can transfer, let's call it $11.5 million, $11.5 million to someone else. And if they don't do it during their lifetime, they'll have it at death. However, come 2026, under the Trump tax laws, they sunset and it reverts back to 2010 timeframes, which will be about $6.4 million. So there's a delta between now and 2026 to transfer up to $11.5 million per person, where if you don't use it, you lose the opportunity to do it, and you'll only have $6.4 million of exemption left. So the times that we're seeing now, given we have potentially lower stock prices in certain areas, we have real estate depreciation, we have potential business issues. The recommendation that we're sort of going through with clients, and Heidi's going to talk a little bit in the next slide about a specific technique, but one of the things is to look at valuations. And we would call Henry up and say, Henry, look, we need a valuation on this business or this interest in real estate that's owned by a business, to determine if there's a discount available and if there's an ability right now through a discount to transfer wealth to the next generation through various ways of doing it, but at discounted prices. So, and the benefit of that is you're taking advantage of an exemption that's $11.5 million, let's say, or less, but something to that effect, but you're getting leverage out of it. So instead of transferring $11.5 million, maybe you're really transferring 18 or 20 million, but we're for IRS tax purposes, we're saying it's 11.58 million. And given the depressed asset classes in certain areas, and given that we're looking to move that out of, let's say, the patriarch or the matriarch's estate for future appreciation to be moved to the next generation is very, very, very valuable. And now, is a really, really good time. Also, and Heidi's going to touch on this in a little bit, with interest rates being low, it's an excellent time to do this for a variety of reasons, and they're all tax and asset protection driven. The transfer of these assets in trust will potentially, if they're structured right, avoid creditor issues for the beneficiaries, and it's gonna limit the beneficiaries' access. Let's assume one of the beneficiaries is having a marital problem. Transferring it in trust will, if structured properly, avoid a potential problem with their soon-to-be ex-spouse. So there's a lot of benefits to looking at depressed values, low interest rates, and taking advantage of things that may not be there in 6 years from now. And the IRS has already spoken that if you do make these gifts and the exemption reduces as it's supposed to 6.4 million in 2026, they won't look back and what's called claw back these assets and say, really, you made gifts that were worth 11, the exemption's now 6, and there's a tax on that. They won't do that. So it's a good time to be looking at various techniques, to be thinking about valuations, and when in doubt, you give Henry a call and you say, look, can we get a valuation on this, or can you give us an idea as to what we think the value of this asset would be in thinking of doing this?
Thank you, Stephen. By the way, 2026, although right now that's the law, there's no guarantee that $6.4 million will remain at that level, because if there is a power switch in D.C., who knows what we're going to be facing. Having said that, let's switch to the next slide. And Heidi, can you, give us an example of how the low interest rates can maximize somebody's gift and minimize the tax on it?
Absolutely. So in this example, we have a $10 million gift, but we can use assets that have decreased in value, due to the current conditions. So, we would work with someone like Henry and get a valuation for these assets. So we could take an asset that may today be worth $10 million, but pre-COVID it was worth significantly more, and presumably, shortly down the road it will regain some of that value. So it really is a great time to take a depressed asset and do something like this, or a sell to a trust. So in this particular case, we take these $10 million worth of assets and we put it into a grantor retained annuity trust, which basically means the grantor is going to get an annuity back. And in this case, we have it set up for 2 years, and the IRS publishes a rate every month, and it is currently very, very low. So it's a great time to do a GRAT, 0.8%. So in this particular example, it's set up to be what they called a zero-out GRAT. So when you apply this 75/20 rate over the 2-year period, it's calculated as if, the grantor is going to take the full dollars back plus the 0.8%. So there's no gift tax consequence on the actual gift to the GRAT. But there's growth when you invest those assets, and we've assumed an 8% growth rate here over the 2-year period. And as you can see, at the end of the first year, the grantor would receive $5.7 million, a little over 5.7, and then at the end of the second year, the grantor, the grantor would receive just a little over $5 million, and he would also receive the same at the end of the second year. But because of the growth on those dollars at an 8% rate, the amount remaining in the trust would be $1.1 million. So you've effected a tax-free gift to a trust for your family, or to a particular family member. You can structure it however you like, and you remove that from your estate. So that's a home run.
That's terrific. That's a terrific tool to transfer appreciation in a trust to the next generation. Steve, when we go to the next slide, it's kind of bringing it home. It's the whole issue of how do you ensure that your wealth, your estate, is fully protected. What are the tools? What are your thoughts on that, Steve?
No, it's a great question, and we're each, when we sit with clients on this, a lot of our clients, Henry, you mentioned matrimonial issues, and they've never been more, really at people's hearts today. When you look at the divorce rate in the United States of America, specifically in the Northeast. So when we're structuring a trust, whether it's a receptacle for the GRAT that Heidi just mentioned, or other techniques, whether it's a life insurance trust or another type of a completed gift trust, you have to look at the jurisdiction that you're creating that trust in. Some jurisdictions have better creditor protection laws than others. So for example, if you're a New York resident and you're looking to create a trust, there's many reasons why I wouldn't create the trust in New York. Some of which is a trust can't exist for a very long period of time in New York under common law rules, but creating a trust in another jurisdiction like Nevada or South Dakota could potentially give the beneficiaries of the trust better protection. The trust may, in some circumstances, exist in perpetuity forever without another taxable event for estate, or another tax called generation skipping tax for many, many, many generations. So, and there's recently, CNBC had an article recently about someone who created a trust in South Dakota, and that's being litigated. South Dakota, under Supreme Court precedents in that state, is very protective of their trust laws. So when someone creates a trust there, you're actually taking advantage of the laws in those jurisdictions. And there are certain things that you need to be cognizant of. You need a trustee in that jurisdiction. But there's also techniques such as what's called a silent or a quiet trust that you can create in certain jurisdictions, like South Dakota, Nevada, Delaware, for example. You can create a trust and the beneficiaries may never know that trust exists if it's created properly. So if you have issues with, your children, or if there's a second marriage situation, or in some cases a third or a fourth marriage situation, and you want the beneficiaries maybe to be taken care of, but not necessarily be stuck with notice requirements and accounting, it's something that needs to be discussed and considered. On top of that, when you have more beneficial laws that protect the beneficiaries, it's something that needs to be discussed with clients to make sure you're doing this in a jurisdiction that makes sense. Ted, I know you've had some experience in that area as well that we've had. Anything you want to add on that?
Yeah, I mean, my clients, the high net worth clients, clearly consult with attorneys and myself on asset protection. One comes to mind. I have a physician that had very well-to-do and a high-risk specialty. He actually created a trust in Nevis to get his assets offshore to help protect them even further. So asset protection for the wealthy is very, very important. They spent lifetimes creating this wealth, and it could take seconds to lose it. So very important topic.
Ted, to your point of creating a trust offshore, wouldn't that automatically trigger FBAR compliance issues and all kinds of additional filings?
Oh yes. It's not fun every year to do all of the compliance, but in this case, the client, at the time when it was set up, which is probably a dozen years, felt that it was worth it. Actually, at a recent meeting I had with he and his wife, they are actually thinking at this point that laws in the U.S. and the ability to get insurance in the U.S. have come much further in the past dozen years. So he's thinking at this point maybe unwinding that trust and bringing the assets back on shore.
Excellent. Usually as we get closer to the end of our webinar, we go to questions. And Amanda, our final slide is actually, do you have any questions? And as Amanda suggested, the audience can type in questions. And Amanda, do we have any questions from the audience?
Yeah, we have a few questions. So one of the questions was, how does a letter of intent work with the trust?
That's an interesting question. I'm not sure where this is going, but Steve, you want to take a stab at it?
Sure. I think the question may be, so if there's a trust and there's provisions in the trust for distributions, some clients are inclined to provide a letter of wishes that sort of go further. It's not legally binding, but there's guidance to the trustee of, for example, it's okay to distribute typically for health, education, maintenance, and support. That's pretty sometimes clear, sometimes not. But let's assume that there's an intent here that they really don't want the beneficiary to be asking for a Porsche. Then they may put that in there as their guidance. Please don't get anything that is, overindulgent for, the beneficiaries. It's their intent that they don't, live that lifestyle, etc. So to us, it's probably a letter of wishes where the trustee can be guided further by, even though it's not legally binding, by the creator of the trust to advise accordingly as to what their wishes are separate and apart from the trust.
I have a follow-up based on my experience with some clients. The letter of wishes written by hand and signed, dated, if there is no formal will, could it substitute for a will? Steve, what are your thoughts?
If there's not a will, it depends on, I guess, on the state you're in. If there's not a will and there's a writing that is intended to be a will, depending on the jurisdiction, there are ways that could go to a court proceeding to ensure that the court would determine whether that will was authenticated and was that person's last will and testament.
Excellent. Amanda, we probably have time for one more question. So do we have another question?
Yeah, so one question that someone had was if they should have items revaluated if they already have them in a trust. If kind of the way that the trust is distributed is monetarily rather than percentage, if that would then need to have another valuation done, or if they should wait.
Heidi, do you want to take a shot at this?
I will try. I'm not sure exactly what they're asking. A lot of times you'll see when a trust ends, it will be divided, equally among descendants. If it's that sort of situation, then you can always try to have the beneficiary sign off on the division, so you don't have to go to the expense of getting a valuation. But if there's any kind of close call or you think someone's going to complain, then absolutely you should get it valued at the time that you are making the distribution. Or if the trust requires you do equal distributions, it's always wise to get a valuation.
Sometimes we get called in as appraisers, business appraisers, when there is a mix of different assets, and we can actually have a workaround, a formal valuation, if we sit down with the attorneys and the parties by coming up with a formula that is acceptable to everybody that they could agree upon. And that saves some money, and it's pretty much consistent with what we would come up if we did a formal valuation. It simply saves them money for a formal valuation report, which may not be necessary if they can stipulate in the agreement as to the formula. Anyhow, we are a couple minutes over, and like we've done in the past, to the extent that we have not been able to answer your questions, we will circulate your questions to the panelists, and we will get back to you via email with what we believe is the answer to your question. With that said, I wanted to thank everybody for attending our webinar. I wanted to thank our panelists who have done a fantastic job. And thank you, Amanda, for hosting today's webinar.
Absolutely. Thanks, everyone.
Thank you.
Thank you.